sentencing.
Private prisons aren't going to work, John.
Why not?
Because when you cut the dollars, I mean, let's take a look at Ritter's new proposal about balancing the budget. The first thing we cut at DOC are inmate programs. That's the same thing that happens at private prisons. And if the goal is to get people treated starting from day one in, you're going to have to put the money into those prisons. And I know it's not only $19,000 a year to keep somebody in a private prison. Those are the low-level offenders who, in my mind, shouldn't be in the prisons to begin with. So we shouldn't be spending that money on those folks. We should be doing that in the community where it's about half of that cost. So private prisons are not going to be the answer.
All right. Let's bring it back to the sentencing reform aspect of this. You were able to get Republican buy-off last year for these sentencing reforms because guys like me said, wait a second, this doesn't make sense. Let's go ahead and change this. I have a feeling there's going to be another big step there. Weren't you kind of nibbling around the edges last year instead of really going in at some of the big stuff? I see the defender saying yes, so go ahead.
Well, as you know, we talked about before, I'm not a big process guy. I've certainly had to slow down. I think there are other issues we can deal with. We have some task force now. The big comprehensive sentencing reform is going to come, I hope, but it's going to probably take us 2 years to get that done.
What does that look like? When you say big sentencing reform, are we saying that if somebody commits murder, they're gonna have community service?
No. When I say big sentencing reform, one of the things I think everybody can agree on is that our sentences, our criminal statutes are too complicated, and they have gotten so convoluted that it's difficult for both the prosecutor, the defense, and the judge to figure out what a sentence actually should look like on that individual offender. If the goal is to individualize sentencing, then we've got to make it, this crime looks like this and this crime looks like that, and we don't have that. And so we're starting with what I hope is a rather innocuous offense, which is theft. Nobody likes having stuff stolen from them, but when we started looking at it, there's like 22 different ways to commit theft in this state now.
Really?
That's crazy.
So what you're suggesting is to tighten up what theft looks like.
Right. I mean, does theft under $1,000, how does that compare to theft of farm equipment? I mean, that's how boutique we've gotten on the theft crimes, and we've done that across the system.
This brings up something called, I know some of the laws are sunset, which was,
yes,
we're going to have this law, it's going to sunset in 5 years. That is, we're going to see how it works, and automatically it goes away. There's been some talk about having some things that are called sunrise laws, saying, before we get a bunch of angry farmers saying, we're going to pass a law against stealing farm equipment, that there has to be some process where we say, wait a second, stealing farm equipment is probably illegal already. Shouldn't we check for that first? Is that where we get kind of duplication of some of these laws? But it feels right, because stealing farm equipment is wrong.
And that's been some of the problem we're trying to deal with. I agree with Doug in the sense that our sentencing grid now looks like trying to put your kids' toys together. The directions you get out at 1 in the morning and your head hurts and you're going to try to assemble this. And so that's part of the problem is simplification. Part of it is trying to figure out what actually are the people we want in prison, okay? Let me give you an example about the people that are in prison on drugs. On average, the ones that are going to prison on drugs are on their 3rd offense, and they've had 2 shots actually prior not to go to prison, and even half of those guys on their 3rd felony, the DA waived the mandatory prison, and they screwed up on a community correction sentence or a probation correction sentence. You need to have that information before you start saying the wholesale, and that's where Doug and I and the other members try to get good information of who's going into prison for what offenses, because once you have that, you can then decide, okay, what is actually the meat of what you want to change? For me, it's violent and repeat offenders are the ones that actually should be in prison for the longer terms, and the folks that aren't should meet certain circumstances. And you should, I agree, I think there ought to be separate grids for drug offenses versus property offenses versus violent offenses. Trying to make everything fit into one grid doesn't work. That's why you have...
When you say grid, bring it down to my level. What do you mean grid?
There's 6 classes of felony. And so you would think all offenses fall under these 6 classes, and it's fairly simple. It's not. Okay, there's presumptive sentences and mandatory sentences for each of those 6 classes. Okay, then there's mandatory minimums that are the minimum of the actual sentence versus mandatory minimum that are the halfway point. Okay, then there's extraordinary risk crimes that then creates another level to this grid. So that's when Doug was talking about it's complicated, and that we ought to say you ought to be able to look at this offense, go to the statute book and say...
in other words, I steal a car.
Right.
I would think that would be pretty simple. You stole a car, but you as a prosecutor have to decide, no, we're going to prosecute you for this crime, or we could have done that crime, or this level of felony versus that level of felony, or since I did it on a farm, is it a farm equipment crime, so on and so forth. You guys, both of you agree that that needs to be simplified. So
yes,
and the other part of it is we can't make it more complicated.
It cannot be more complicated, and it needs to be more simplified. And one of the things that I'm hoping we can look at, for instance, are minimum mandatories. The charging decision by Don at times sets the bottom number. And I think that ought to be a situation that if we're doing individualized sentencing, the judge should take everything into consideration. Impact on the victim, what client's prior record looks like, what the offense was, and make a sentencing decision.
Aren't you going to be tying his hands when you do that? Because right now, Don, as the prosecutor, can say, I'm going to charge Caldara not just for stealing a car, but for stealing farm equipment. An at-risk victim, and that means the minimum sentence is going to be higher.
Right. And
as a good prosecutor, as a citizen, I want you to go out and get I want you to punish these guys the best you can. Isn't that what?
But see, I think the reverse is true. I think those charging decisions have tied the bench's hands. And it's the bench's decision as to what the appropriate sentence is. We can argue all day about whether I think he should get probation, whether Don thinks he should go to prison. I think that's what we have judges for. Make the call.
Right. And my response to that is we have the discretion to file a certain level of a felony anyway, which happens to correspond with a certain box to begin with. So we have that discretion. I think really the issue that Doug is talking about is how much discretion does he want with the judges versus how much discretion with us. And the federal system has looked at that. Very recently they changed the mandatory minimums of the box for crack cocaine because it was disproportionate in how it was being applied. So that's always a difficult decision because I have judges that I love their discretion exercise and ones that I don't. And I'm sure Doug feels the same way.
Absolutely.
So the question is, who are you going to give the discretion to?
In other words, when you're talking about these mandatory minimums, they're very popular for guys like me. The 3 strikes and you're out law makes perfect sense to me. So if the first crime
But not if the 3 strikes are felony thefts, and now you're looking at a lifetime sentence for 3 property crimes. That's the problem. 3 strikes on violent offenses, absolutely agree.
Right, for a violent offense, I'm the kind of guy that says 1 strike and you should be out.
Well, I understand that, John, but even the 3 strikes started from California.
Right.
And even the district attorney that pushed those through, Gil Garcetti, now says that was a mistake because the net is too wide. We're picking up people that should never spend that much time.
To illustrate it, the first crime I committed was an assault. I did my time. The second one was an assault, and I did my time. And then I steal a pack of gum at 7-Eleven, and I'm going away for life. Does that make sense? Do prosecutors like the 3 strikes and you're out?
Yeah, because we never do it in the situation that you just described. Okay, every day. In fact, we could, on a 3rd offense that I described, a 3rd drug offense, we could make them go to mandatory prison because unless we waive it, they have to go. And so we exercise our discretion both for not just mandatory minimums, but mandatory prison all the time. And so we're very thoughtful about when we apply habituals. And I know Doug says there's other DAs that take a different path and a different direction.
If we had 22 Don Quicks, I would agree with that. We don't.
Listen, if the public defender is saying you're a good prosecutor,
it's a good thing I'm term limited.
That's not what you want. All right, bring it back to these minimums. So, will the CCJJ recommend to the state legislature in the next couple of years to change those mandatory minimums? And how will people like me feel about it? How will the conservatives who want to be hard on crime versus the guys who want to balance the budget without raising taxes?
I hate to bop the balloon after Doug just filled it up for me, but that was one of the discussions we had a year ago, and that was one of my strong objections, that there was a recommendation to reduce the mandatory minimums to the minimum presumptive sentence, and there was some people like myself and a victim's rep that stood in the way of that, and we managed to get that put aside. So that issue, will it be looked at? Yes. Is it going to take some time to get through to make people comfortable? The answer is yes, because I think there is very disparate views that Doug and I have about the mandatory minimums. I think there can be some tweaking and maybe some look at the evidence, how we're using it, and figure out are we using it the right way. And I think Doug would like to get rid of most mandatory minimums altogether and turn it over to the judges.
Guys, talk to me about probation, because from what I've heard, and again, I'm doing this as a fiscal conservative, a lot of the money I'm spending to keep guys in prison are guys who break their probation.
Or parole.
Or parole. What's the difference between parole and probation?
Probation is going to be pre-prison. It's going to be a sentence to probation, which would happen before somebody went to prison.
So in other words, I'm sentenced to a year, but I'm going to give you 2 years of probation, which means you behave for 2 years, check in with your probation guy once a month or whatever, and then you don't have to do the year in prison. If I already do, I'm sentenced to a year in prison, but I get out in 6 months.
You're going to do a mandatory parole period on the back end of that prison sentence.
And parole basically, or probation, means I'm supervised out in the real world.
Yes.
Would that be the simplest way to put it?
Yes.
All right. But I'm been told, and tell me if I'm right, that a lot of the guys I'm paying $32,000 a year to keep behind bars